10 seconds, 5 seconds, start. It is also to be noted that though the power of the court under the proviso appended to Rule 1 of Order 7 is circumscribed by the words shall not be later than 90 days, but the consequences flowing from non-extension of time are not specifically provided, though they may be read by necessary implication. Merely because a provision of law is couched in a negative language implying mandatory character, the same is not without exceptions. The courts, when called upon to interrupt the nature of the provision, may, keeping in view the entire context in which the provision came to be enacted, hold the same to be directory, though worded in the negative form. The mandatory or directory nature of Order 8, Rule 1 shall have to be determined by having regard to the object sought to be achieved by the amendment. It is thus necessary to find out the intention of the legislature, the consequences which may follow, and whether the same were intended by the legislature have also to be kept in view. In Raza Sugar Corporation Limited versus Municipal Board Rampur case, a constitution bench of this court held that the question whether a particular provision is mandatory or directory cannot be resolved by laying down any general rule, and it would depend upon the facts of each case, and for the purpose the object of the statute in making out the provision is the determining factor. In Sangram Singh versus Election Tribunal, considering the provisions of the code dealing with the trial of the suits, it was opined that now a code of procedure must be regarded as such. It is procedure something designed to facilitate justice. To technical construction of sections that leaves no room for reasonable elasticity of interpretation should therefore be guarded against. In the facts and circumstances of the case, the maxim of equality that an act of court shall prejudice no man shall be applicable. This maxim is founded upon justice and good sense, which serves a safe and certain guide for the administration of law. The High Court's orders are clearly indefensible and are set aside. The appeals are allowed but without any order as to cost. In Gujarat State Cooperative Land Development Bank versus P.R. Mankand and others, it was held that the term dispute means a controversy having both positive and negative aspects. It postulates the exertion of a claim by one party and its denial by the other. A plain reading of the reference made by the central government would show that it does not refer to any dispute or apprehended dispute between the bank and the federation. The reference made by the central government for adjudication by the industrial tribunal is wholly redundant and uncalled for. Even if the settlement is set aside, the federation would not gain in any manner. On the contrary, the appellant bank would be a big loser, as it will not only be very difficult but almost impossible for the bank to recover the monetary benefits already paid to its employee under the settlement.